Great. Good afternoon. Welcome to At the Brink, Pioneering Solutions for Endangered Wildlife. My name is Mary Hollingsworth. I'm the faculty director of Harvard's Animal Law and Policy Clinic. Previously, I was a senior trial attorney in the Department of Justice's Wildlife and Marine Resources section. So our topic for today's panel is near and dear to my heart. Before we get started, I would like to encourage you to submit any questions you have for our panelists via the Q&A button. It is my great pleasure to moderate this discussion on the protection of endangered wildlife. I have with me two attorneys whose work I have admired from a distance, and I'm thrilled to have this opportunity to interview them. First, I am joined by Erica Fuller, Senior Counsel for Conservation Law Foundation's Ocean Program. CLF is a champion for the environment in the New England area, working on a range of issues from safeguarding drinking water to protecting ocean habitats. Next, Ramona McGee, Senior Attorney and Wildlife Program Leader for Southern Environmental Law Center. SELC's mission, in part, is to preserve the South's rich biodiversity and ensure that all communities in that region have access to a healthy environment. Welcome. Erica and Ramona, you've taken somewhat different paths to your current positions. And would you mind telling us a bit more about your background and what led you to pursue a career in wildlife conservation?
Sure. Would you like me to go first?
Sure, please.
So my father was a marine biologist, and I was always interested in marine conservation. I grew up going to Woods Hole in the summertime, but when I was about 6, I decided the only thing I wanted to do was study grizzly bears. So I went, I had a sort of circuitous path. I went to the University of Georgia's School of Forestry and was a wildlife biology major. The reality was there were no jobs. So I went from college to vet school. I practiced large animal medicine up here in the Metro West area for about 20 years after graduating from vet school. A combination of a lot of things, including that it was not the James Herriot days any longer, made me want to change professions. So I started law school in 2005. University of Maine had a really good marine resources program at the time, and commuting distance worked. And for the first 2 years out of law school, I practiced corporate law at Todd and Weld in Boston here, just to pay back my school loans. And at that time, the firm allowed me to be local counsel for groups like Food and Water Watch and to continue doing some pro bono work for Earth Justice. So eventually I landed a job at Earth Justice, where I was for 8 years, and then Conservation Law Foundation for the last 6 years.
Great, thank you very much. Ramona?
Yeah, so I grew up in a small town in Alaska, where I always loved the natural world, appreciated all of that, loved wildlife from a young age, but was never quite sure whether I would go the biology route like Erica started out on, or the law route. So I spent my summers working with the Alaska Department of Fish and Game out in the rivers, doing fish tech work, loved it, but also saw some of the limits there in terms of being able to advocate for actual protections. I also was a high school debater. I really liked that sort of work and knew that was something I enjoyed. So when I went off to undergraduate, I did an environmental studies degree and decided to kind of focus more on the advocacy route, but still try to get some of that sciencey background. And then I graduated, worked with some nonprofits for a couple of years just to really make sure I wanted to do law before I made that financial investment. I did. And so then went back to law school. And after I graduated, clerked for a year, and then was lucky to land here at SELC as an associate attorney.
Great, thank you very much. So early in my career, I worked on an Endangered Species Act case involving the critically endangered dusky gopher frog, which really changed my view about the limitations of the law in preventing the extinction of a species. Both of you have advocated tirelessly for critically endangered species, Ramona, the red wolf, and Erica, the North Atlantic right whale. to what extent do you think the law is successfully preventing the extinction of these species? And what do you see as the limitations in the existing law that may prevent the recovery of the species? I don't know if Erica, if you'd like to go first.
Sure. So, to the first question is, do you think the laws successfully prevented the extinction? I'm not sure the laws we have so far have successfully prevented the extinction of right whales. It's kind of too soon to tell. We're down to 370 animals and something fewer than 70 breeding females. What might have contributed the most to their recovery after whaling was these 1930s agreements to stop whaling. The population had gotten as low as somewhere around 200 at that time. So then Congress enacted MMPA and ESA in the 1970s. The purposes were broad. And they did recover in sort of that golden period between enaction of the Endangered Species Act and 2010, when we had sort of a regime shift in the Gulf of Maine caused by climate change, and the waters there were warming faster than about 99% of the world's oceans, and it shifted their prey, which are these little rice-sized copepods, and reversed their upwards trend. So now they have been since 2010 rapidly decreasing. Their rate of decline has gone up a lot. I think there are some provisions of the Endangered Species Act and the Marine Mammal Protection Act that are helpful. Certainly Section 7 that imposes mandatory duties on the agencies when they're licensing something like a commercial fishery to ensure that the activity doesn't cause jeopardy to the continued existence of the species or the critical habitat. In addition, the Section 9 take provisions have been helpful, but the biggest threats to right whales at this time are accidental entanglement in commercial fisheries, in particular the lobster fishery, and getting struck by boats. And we have not really managed to get either one of those under control in the last decade. And the limitations I see is that under the Endangered Species Act, when Section 7 consultations happen, the National Marine Fisheries Service ends up being both the action agency and the consulting agency, which is an inherent conflict of interest. We have one part of the National Marine Fisheries Service that's charged with like getting the very most out of commercial fisheries it can get, and then a protected species division, which is charged with the survival and recovery of the species. And that conflict of interest has not worked out well for right whales. Another limitation is that when these take limits are exceeded, the activities are almost never stopped. In particular for right whales, because no take is actually lawfully allowed just because of the status of the species. Whenever they exceed a take permit, it just means there's a new consultation and it starts the cycle all over again. The critical habitat provisions in the Endangered Species Act haven't had much teeth for this particular species. One example of that is that the entire Gulf of Maine is designated as critical habitat for right whales. But when offshore wind was proposed in the Gulf of Maine, that designation really had no effect because it was such a large area. There wasn't anywhere to like single out and say, oh, this area deserves special protections. Another limitation is that recovery programs are consistently and significantly underfunded. And at least in the case of right whales, there's been a fair amount of political interference, even though the Endangered Species Act technically doesn't allow for economic impacts to be considered. They creep in. And with respect to the Maine lobster fishery, there's been bipartisan agreement that lobsters matter more than whales.
So Erica, you packed a lot into that answer. I think what I want to comment on is, you've talked about this conflict where in the Endangered Species Act, you have to do, if Section 7 consultation is triggered, typically you have the action agency consulting with the expert agency, but sometimes they're the same agency, right? And that creates that
Yeah.
conflict, and may also lead to sort of a lack of enforcement if take limits are exceeded, right? I think we've had the same sort of conversation about the Department of Justice, the section that is charged with enforcing the Endangered Species Act is the same section that's charged with defending the agencies and their decisions. So how do you end up playing this dual role? And at some point, one of those I guess has to fall by the wayside, right?
Right.
But it's sort of playing out the same way on the justice side. Thank you. Ramona, let's turn to you, and then I suspect that we'll have some discussion around these issues because I feel that there are probably some of the same issues happening for the red wolf.
Yes. I think I'll start off a little rosier than Erica in terms of the ESA being successful. So to the first question of whether the ESA has been successful in preventing extinction of the red wolf, unequivocally, yes. We would not have red wolves today, but for the Endangered Species Act. The red wolf was one of the first species listed under the ESA, actually under the precursor to our current version of the statute. And it was a huge success for years. The red wolf was on its way to extinction in the 70s, and the Fish and Wildlife Service saw that and went and found all of the red wolves that it could, put them into a cooperative or breeding program. And then in 1987, under Section 10J that authorizes experimental populations, the Fish and Wildlife Service reintroduced red wolves into eastern North Carolina. And for years, the population grew steadily. We had more than 100 wolves for over a decade. The red wolf reintroduction was actually the model for the Yellowstone wolf reintroduction. Some of the same folks worked on both of those. So I always like to emphasize that like for a long time, this worked great. And even now, a lot of the reason that we do still have red wolves in the wild in North Carolina and have some hope for the future is because of successful implementation of the Endangered Species Act and successful enforcement by citizen groups who bring in lawsuits to ensure that the agency is charged with managing the red wolf or otherwise involved, like state agencies, were following the law. So the ESA has been very successful for the red wolf in that regard. But in terms of limitations, I think I mostly echo what Erica was saying in terms of a lot of the external sort of limitations. I think the law, the way it's written, is very clear and very strong. It's when there's nuance in the implementation or the underfunding and the understaffing and the politics that come into play. I was mentioning to both Erica and Mary before this that I was watching a House Natural Resources Committee hearing about Section 10J of the Endangered Species Act right before this panel, where there were a lot of questions and confusion about how that section works. So it's more of those issues that I see where the limitations of the Endangered Species Act come out.
Do you think from what you observed in this hearing, do you think that there's a way to sort of educate both the public and the new administrations on sort of how to balance these sort of competing interests? Like, for example, with the whales, I mean, Erica, you can speak to this better than I can, but the lobster industry in this region, I mean, is such an important and sort of iconic industry in this region. But how do we sort of get people to see that these two can sort of live together, that we can find sort of a middle ground here, if you think that's possible?
Yeah, I think a lot of groups not just CLF in the region, have sort of preached a message of coexistence, because no one is looking to put a really iconic industry out of business. I do think we believe that right whales and fishing can coexist. I think in those areas of highest risk, what we have suggested is that, and I see this question in the chat as well, about alternatives to fishing in those areas of highest risk. And so we have collaborated with other fishermen and with other NGOs and with scientists and engineers to try to come up with a new way to fish. And that new way to fish is ropeless fishing gear. So it's the ropes that go from the surface buoy to the traps that are entangling whales. And under this new way, you would trigger the trap up from the bottom, not unlike you unlock your car door from your kitchen, and it would come to the surface. And there are possibilities, and that have become, over the last 5 years through trials, we know not only are they feasible and do they work, but there's good evidence they could become more economically viable if they were more widely used. So I think there is a way for them to coexist. Currently, the way that they coexist is there's big closures where there's no fishing. So the idea of, that's not palatable to a lot of the industry, but the idea is that, yes, you could fish, but with different kinds of fishing gear.
Thank you, Erica.
And can I add a little bit on red wolves on this idea of coexistence?
Yeah, please.
So for those who aren't familiar, I mentioned Section 10J and how that authorizes these experimental populations. That section of the Endangered Species Act was added specifically to allow for flexible mechanisms when reintroducing a species back onto the landscape. So directly addressing the concerns of the communities where these species were being released. That was the whole idea behind 10J. And that's why there's a special rule for each of these populations that lays out the kind of weaker protections for the species than would otherwise apply under the typical ESA framework. So just to kind of note that 10J actually is designed to do this. And that's the whole idea behind it, is to help ensure there's a better balance.
Great, thank you. So both of your organizations have in the past relied on lawsuits in federal court to protect these and other endangered species. With the changes in the federal judiciary, what role do you think federal litigation will play in the next few years in conserving species? And do you think new strategies will be needed to effectively protect critically endangered species moving forward? Ramona, would you like to?
I was going to say, I'm happy to start on this one. So I think federal litigation will still be key. It's going to be a big part of it. These are federal statutes that we use, and it's not just the Endangered Species Act and the MMPA. It's also MIPA, which we will be relying on the statute more and more. It's other statutes that come to bear, FOIA, all of those. So we will keep doing that. And I'll say, in terms of the changing judiciary, here in the South where I've practiced, we've long had a more conservative judiciary than other parts of the nation, and we've still been able to successfully litigate in federal courts and otherwise a lot of these issues. And just to highlight a few examples with red wolves, the judge that we've had on several red wolf cases was a Reagan appointee who is traditionally considered a little bit more on the conservative side. And we've had multiple wins from the environmental perspective in front of that judge. We also have had success in front of Trump-appointed judges in Georgia. We have recently had some success with a judge where we brought a wildlife-based case under the National Environmental Policy Act with a judge who had never found a violation of NEPA, but in this instance did. So we can still win on these issues. It might be different, right? We'll have to be thoughtful and careful, like most lawyers are, and we'll still be able to advance our goals through federal litigation. I tend to be an optimist, so I will give that little caveat for everyone. And then in terms of new strategies, I do think that's really important. I think that we need to work at the state level, both thinking about how to protect and enforce protections for species at the state level in the event that some of the federal landscape changes. And then also, I think that it's important for us to be finding ways to work with state agencies where we can. They have their own interests and charges for protecting species, and they can be important allies. And so those are the sort of things that I'm thinking about in terms of how do we diversify our strategies and continue to advocate for wildlife in the future.
Thank you.
Yeah, the only other thoughts that was great, Ramona. A lot of what I was thinking, I guess it's also a little tricky right now in terms of whether we think the government's even going to comply with court orders in this administration. So it could be that it's really important to get even more detailed court orders than we used to get. And there's also some concern amongst the conservation community about bringing statutes like the ESA, claims under statutes like the ESA and the MMPA out of fear that they will get to the Supreme Court. We're sort of, damned if we do, damned if we don't. I think we'll probably all still bring these claims, and even if we don't get them, the other side may get them to SCOTUS anyway. But there's a little bit of care in terms of considering what claims to bring. And the other, I was super fascinated by your description of Southern judges as being perhaps more conservative, at least up here in New England. Our conservative judges are often the ones that care more about wildlife because they are the ones that actually do hunt or do fish or do. So it's sort of been an interesting dichotomy up here. I also think that over the next few years, strategies like collaborating with unusual partners might be a good idea. In our case, our trial with commercial fishermen in the lobster fishery, I'd say that they're more receptive to this in Massachusetts than perhaps in Maine. And that's where the large majority of the participants in this trial come from. But some of those collaborations are likely to gain more bipartisan support than our litigation. And we've, discussed sort of an increased use of petitions for rulemaking under this administration. It can be really frustrating because often the agency just never responds. But if they do deny our petitions under the Administrative Procedure Act, then we can challenge that denial, and it could be the next administration or so before that's going forward, given how long things usually take.
Right. Yeah. So as I think my dusky gopher frog case was one of the last ESA cases to reach the Supreme Court. So I absolutely understand the fear, and also you just can't control it, right? We were in a defensive posture, and just by defending the suit, we ended up in the Supreme Court. So you're right that there's just so much that you can't control in a litigation setting, which might, in some cases, warrant looking for other paths depending on the issue, just to avoid. But again, if the suit is brought by another side, it is what it is, right? In terms of, I think we would all agree that that maybe this current administration is not necessarily the most supportive of Endangered Species Act protections. We don't know wildlife protections, but there is potentially that is a concern. Is there, and I know, Ramona, you sort of touched on this a little bit before, but is there still hope for these two species, the North Atlantic right whale and the red wolf, and how much of what happens, we're seeing obviously a massive reduction in the federal workforce and at NOAA, at Fish and Wildlife Service. How much of sort of what's happening there how much of that will matter for the species that you've spent so many years trying to protect?
Yeah, I can start with the red wolf. I'm absolutely nervous about the next few years for red wolves and other species here in the South. It's not just red wolves that will suffer under these different rollbacks and underfunding and cutting of staff. But in terms of hope for the red wolves, I do have hope for the red wolves. We have been through political swings before with this species. We've been through all sorts of different political attacks with the species. During the first Trump administration, there was a proposal to severely restrict the area of protection for red wolves in eastern North Carolina and allow them to be shot off of federal lands. That proposal was never finalized. We brought successful litigation on different issues that resulted in a settlement in 2023 that requires the Fish and Wildlife Service to prepare release plans for 8 years total. And that's really important, and I think will give some ongoing hope for the red wolf. So I'm hopeful because we've been through some of this before. I'm also hopeful because right now the red wolves are doing a lot better than they had been. Back in 2020, we had 7 known red wolves in the wild. We're now up to about 16 known red wolves. That's still really, really small, but that's still a lot different than having barely one breeding pair in one pack. So I see a lot of glimmers of hope. It's tempered by some uncertainty right now. But I think that we'll still be able to work with the statutes that we have. I also mentioned state agencies earlier. There's some glimmer of hope there where our Wildlife Resources Commission that historically had some policy statements that were very anti-red wolf issued some new resolutions or policy statements this past year supporting red wolf recovery and committing the agency to work with the Fish and Wildlife Service. So there are things like that that are giving me hope to see how things will kind of settle out in the next few years.
Thank you. Erica, what are your thoughts?
Yeah, I'm an optimist too, so I hope I'm not being Pollyanna here, but similar thoughts. Right whales keep having calves, even though their calving intervals gotten really long, from an average of like 3 years between calves to about 10 years. But this year we have 10 calves this season from 70 breeding females, so that's pretty good. We do know we need 50 for recovery, but if we're just hoping to like get through the next 4 to 8 years, I think there's definitely hope. And they're a really resilient species. They are, this past year, 2024, there was a whole lot more monitoring on the species, in part from IRA funding. And as it turned out, right whales were finding food in places that we didn't know they had previously been feeding. So like they were out in the canyons, like Hudson Canyon off of New York City. Not that that's a super safe place for them to feed, but they are congregating and aggregating in unusual places. Also this fall, we've had 90, so like a quarter of the population was in Jeffrey's Ledge, just north of Gloucester. So there are some patterns that we're seeing now with increased monitoring that we weren't aware of before. The work that the NOAA Fisheries or National Marine Fisheries Service is required to do under the Marine Mammal Protection Act and the Atlantic Large Whale Take Reduction Plan is still projected to go forward. So that work is on entanglements and on reducing entanglements in commercial fisheries. So far, that work hasn't been canceled, so we're remaining optimistic that that we will have new measures recommended for the new rule that's required by the end of 2028. And for good or bad, the pause in offshore wind development in southern New England and Gulf of Maine may be giving a slight reprieve to this species. Offshore wind development is associated with increasing ocean noise, which scientists were concerned would have the effect of forcing right whales out of their normal foraging habitat. Southern New England is year-round habitat, really important for them. So we may have a little window to monitor the effects of operational noise for the 3 projects that will be built out, and to learn a little bit more about the threat of offshore wind, floating offshore wind entanglements, which is what's planned in the Gulf of Maine because the water's too deep to drive monopiles. So I do remain hopeful.
Okay, well, that's good to hear. We need hope right now, right? I'm going to pause for 1 second to ask you a question from one of our students. And the question is, how much of a difference is there between sort of the treatment or the perception or maybe even the protection of endangered land animals versus ocean animals? And I'm going to add to that by saying, do you see differences in how we obviously have potentially 2 different agencies that are, so for the audience, there are two federal agencies that administer the Endangered Species Act, and roughly it translates to the Fish and Wildlife Service managing land animals, and NOAA managing the marine mammals. But how much do you think the differences, if you think there are differences in their approach, how does that affect the protection of the species?
I could start.
Okay.
Please do.
I think for right whales, so this is a species that goes all the way from Newfoundland to Florida. So it's really tough and really, really expensive to monitor. They're super difficult to see because they don't have a dorsal fin, they don't play, they're dark, they look just like the water. They are very difficult to see, and they've proven really difficult to tag, not because you can't get a tag into them, but because it's really causes major health issues. In the last few whales that were tagged with a tag that, or right whales that were tagged with a tag that could last for anything longer than a couple of weeks, had enough serious sort of necrosis and tissue disease that they died. So we are, there's all kinds of innovative technologies to monitor this species. Like, can we see them from space with a satellite? The Canadians invested a lot of money in that. The Navy is investing some money in that now. The Navy is tagging anyway, regardless of health risks for right whales. But I think I find this species incredibly difficult to track. And it on first blush, it seems like it would be easier to track wolves or a grizzly bear, something that you could put a collar on or a tag or some way to understand better population dynamics.
Do you think that any differences really come down to sort of the practical side of tracking the animals, tracking the species, and conserving them as sort of is that
I think maybe what you were trying to get at, and I just didn't hear it the first time, is that legally, I think they're a little more difficult as well, just because critical habitat, is often based on behavior. So they need foraging habitat that covers, thousands of miles of the Atlantic Ocean, foraging and breeding habitat. Whereas a terrestrial species probably needs more limited critical habitat. And so it probably gives it better protections than critical habitat designations have done for things like right whales, where there's so much of it, it's just almost meaningless.
Okay, thank you for that. Ramona, what do you think?
Yeah, I think so. I haven't done as much work with species that are managed by the National Marine Fisheries Service like Erica has, but my perception has been that wildlife out in the ocean, I think it is a lot harder to track for all the practical reasons that Erica is saying. I think there's also a disconnect for the American public and other people, just that you don't interact with or understand the ocean, right? Like I hear these statistics all the time about just how much of the ocean is uncharted, how many species are unknown there. And I think some of that kind of comes to play too in these sort of discussions, whereas with terrestrial species, because humans have developed so much of our land and live on the land more directly, we do see and interact with these terrestrial species more. So that's a little bit more of a philosophical kind of thought. But then, Mary, you were mentioning the different agencies at play, and to kind of pick up on that, I think there are differences between the agencies and how they approach the Endangered Species Act. The Fish and Wildlife Service has a much longer list of species under its jurisdiction than the National Marine Fisheries Service. That's probably partially because of all these undiscovered or unknown species that we're talking about. But with the Fish and Wildlife Service, because of that larger number of species they are managing, they have approached things a little differently. In particular, for threatened species, historically, the Fish and Wildlife Service had a rule that was called the blanket 4D rule that said when a species is listed as threatened, it will automatically receive the same protections as an endangered species, unless we do a species-specific rule that carves out some of those protections. That was something that the first Trump administration removed. It went back in place under the Biden administration, but it's been a way that the Fish and Wildlife Service has approached endangered and threatened species protections differently than the National Marine Fisheries Service that did not have that blanket 4D rule, and instead would always, my understanding is always issue a 4D rule for a threatened species. But Erica or Mary will correct me on that if I got that wrong.
No, that's right.
Yeah. And I just sort of, I've always thought of this as sort of like a pragmatic issue. If you've got 1,600, I think that last time I checked, Fish and Wildlife has what, 1,600
I think that's right.
under, and NOAA is more like 100 or so, and it would just be, I would assume, like a nightmare to have to issue individual 4D rules for all of those species. I've always also had the impression that NOAA, at least at times, has been more in some respects on the cutting edge of, you know, sort of pushing the limits a little bit further in terms of protections in some respects than Fish and Wildlife Service, but it may just depend on the species and the circumstances.
You know, I think that depends on the species. I certainly think for right whales, it's been great, but there's a whole bunch of other large whales that are also endangered. They don't have any critical habitat designations, no real protections in place. So I do think it depends on the species. And it really depends on whether they interact with commercial fisheries or not. For those species that don't interact with commercial fisheries, there's very little, but for something like Atlantic sturgeon, which is caught in a lot of commercial fisheries, there are, you know, a suite of protections to try to protect them. So
I think that's right, Erica. My experience has been more so with the like Arctic seal species, you know, in the Alaska area. And I think you're right that there are a number of factors that come into play. Ramon, I think you were touching on the sort of public perception of different species and how that plays into maybe the support for protections and taking certain measures. And that's what leads me to my next question, which is how important do you think it will be for members of the public to become or remain engaged on these issues, related to wildlife conservation in the next few years. I'm curious, we did this poll during the EFA conference in November, asking people's opinions of whether or not they think the general public still remains very supportive of protections under the Endangered Species Act. And I'd be curious to see what you think and how that plays into sort of ensuring that there continues to be protections in the next few years.
I think it's so important that people remain engaged in expressing their support for endangered species and the different mechanisms we have for protecting them. I think that education is key to that, not just education about how the law works, but also people understanding how interconnected our ecosystems are, so that protecting a keystone species, whether it's the red wolf or a right whale or whatever it might be, that has all sorts of domino effects that affect us. Even if you don't care about that particular individual animal, surely you care about, I'm thinking about bats, about having safe crops for us to eat. Bats are key to pest control for crops, things like that, that people need to understand that, I think, to help continue that support and overcome some of these misperceptions about, wolf versus people, that sort of narrative. So that's something I feel very strongly about. And I also think that poll after poll has shown that the American public supports the Endangered Species Act. One of the more recent ones I've seen said, I think 84% of the American public supports the act. That's bipartisan, like it's a couple points higher for people registered as Democrats, a couple points lower for those registered as Republicans, but still huge majorities, right, of across the political spectrum. And I think that's telling. It's really when you have kind of discrete issues that come up that we work through, as Erica and I are talking about, that you start to hear from some very loud but small contingencies sometimes about being concerns about the Endangered Species Act and how it's being implemented. I have a lot more thoughts on that, but I'm going to hand it over to Erica.
No, I'd echo most of that. I also think it's really important that the public reach out to their representatives. I think most of the national groups are doing a really good job on things like action alerts. And while I remain sort of skeptical about the value of action alerts, if you can say that 100,000 people care about an issue and tell your representative that, it makes a big difference. And I also think that all of our groups are doing a fair amount of lobbying to Congress to make sure that wildlife conservation remains sort of on their radar, including like identifying speakers and that will testify at committee hearings in Congress. I also agree that the rubber really hits the road when an endangered species impacts something the public cares about. And I'm thinking about like when grizzly bears have an interaction with a human, for example, in Yellowstone, or decide to leave the park and feed on, cow on a cattle ranch. All of these things are things that the American public also holds value in and really cares about. Certainly things like sage grouse and spotted owls were of such concern that Congress put them in their crossfires, and in some cases took them off the list and took protections away without even following the law. So I think yes, the public really cares about them, but it becomes trickier in our own backyards.
Yeah, and Erica, to that point, and Ramona, to your point about keystone species, I remember for a number of years I was assigned to prairie dog cases, and prairie dogs are another keystone species, right? But people really, a number of people feel very strongly against prairie dogs. They can sometimes be viewed as a nuisance species, and I know trying to sort of get the public on board with protecting this really critical species can be tough. But I think you're right that that public engagement is so critical. So Erica, we have actually a very specific question for you, if you don't mind.
Sure.
The question is, so this is from a vet student who is passionate about law and animal conservation. And she says that, you know, she's really admired your career path, and she wants to know how you think that your background as a veterinarian has helped you in this particular career of yours, and what would you advise for somebody who might be interested in following that path?
Thank you for the question. Well, not unlike Ramona's, I really was a science girl. This was like and if I were to, you know, try to characterize how my brain is hardwired, I think I'm still a science person. I think I still think more like a scientist than a lawyer. Maybe I shouldn't admit that, but I think that the intersection for those of us who work in wildlife conservation is that we get to use both. Like it's a really unique opportunity to work in this kind of law because I mean, all our cases are based on best available science. MMPA and ESA have a, you know, best commercial and scientific data standard. It's a really high standard. You have to, and to appropriately litigate the cases, you have to read the papers and understand it. You can't just rely on experts to you know, create your claims and develop how you want to argue them. So for me, I loved both. I would encourage anybody who loves both to do this kind of law. The world needs both more veterinarians and more wildlife lawyers. So I'm not saying one career path is necessarily better than another, but it's just never too late to try to switch. And you know, I had kids in middle school when I decided to go to law school, and I'm not sure I'd recommend that to anyone either. But it's never too late to like think outside of the box about what you can do with your career path. And I hope that answered the question.
Thank you very much. Another question that that has been posed, and I really like this question in particular because I think as a lawyer in this space, in the animal law space, wildlife space, and you know, sort of knowing the makeup of Congress, you always have to be thinking a number of steps ahead, not just for your case, but for the whole field. How much do you think that attorneys should be considering, you know, as they're bringing cases to, you know, to protect, you know, in the wildlife conservation sphere, to protect species, be considering what, you know, sort of these legislative fixes? So let's say you win you know, that's great if you can win your case, but how there might be some blowback or some reaction, and there might be some, you know, legislative fixes to these cases. Is it still worth it?
Is that question for me? Because we had
Either of you.
we had Extinction 1.0 happen to us.
Please.
So CLF with partners at Center for Biological Diversity, Defenders of Wildlife and Humane Society, won two really big right whale cases challenging the biological opinions on the lobster fishery, one in 2021 and one again in 2024. But at the behest of the Maine delegation, Congress drafted as part of a must-pass appropriations bill what we colloquially call the Extinction Rider, which essentially gave the lobster industry a free pass for the next 6 years on all Endangered Species Act and Marine Mammal Protection Act requirements, with the exception of one rule that the agency was finalizing, and it had to be separately litigated, but we just won at the First Circuit, so fingers crossed that holds. But it's made for a real acutely aware of the fact that if you win too much, Congress might fix it. So what do you ask for so that Congress doesn't fix it? Now, in case with, for species like right whales that have so few animals left, I think we still have to keep going for the gusto and going for what the law requires, and we think the species absolutely requires. But many people asked prior to that second lawsuit, are you sure you want to do this? And it's something to consider. We do still have the 2021 rule. We were fortunate that the 2021 rule is still in place and has offered some protections, but not enough. And so this legislative fix was really problematic, and what keeps them from going back to Congress and asking for another one if they got it so easily the first time. So that is a real doom and gloom story. Hopefully Ramona has something to counteract that.
No, like I would just kind of pull through a thread that you had mentioned earlier, Erica, about how wildlife groups are lobbying, right? So, and I bring us back to that to say that so much of this work happens outside of the courtroom. So Erica and I are litigating. We also do a lot of policy work. We are thinking about all these different angles, all these different opportunities, the possible blowback, and trying to figure out what's best for the species. And unfortunately, we don't have crystal balls to predict all of that, right? So sometimes it's going to come out differently than what we had hoped or expected, but we still, carefully consider all of those decisions and are trying to fight it on all fronts for the right whale, for the red wolf, and others.
That makes sense. Yeah, I think it's just it's so hard to predict. It depends. I mean, sort of predicting what even opposing counsel or judge is going to do is hard enough, and then trying to layer it with all of these other aspects, I think is an impossible task. I don't know. In my mind, there are certain things you can control, but as to your point, Erica, the law says what it says, and I still go back to the dusky gopher frog. I'm like, isn't this exactly what the statute was for? Is the species who's like nearly extinct because it has no good habitat left? Like, isn't this exactly what the statute is written for? So we have a few more minutes, and I want to make sure I get to this question because I know we have a lot of students watching this, and I've mentioned to you both before that I've had several students say to me recently that you have their dream jobs. They really are passionate about wildlife conservation and a legal career in that field. And what advice would you give students who would love to end up, doing the kind of work that you're doing?
I can start. So I often tell law students there is no one correct path to this place, right? Whether it's environmental law or specifically wildlife law, there are so many different ways to get here. If you want to do it, you'll find a way. I work with environmental attorneys in my office who previously did death penalty criminal defense work and now are doing energy and climate work, right? You can make transitions like that. And I think Erica could speak to that a lot more than me about just changing career paths. And that's true within the law. So I would say keep your focus, right? Stay focused on what it is that you want, but be open and flexible. So you might take a job that isn't wildlife work for a little bit. You're gonna gain all sorts of great skills that will then translate to this kind of work. By way of a little example, when I started at SELC, I was working on red wolves, but then 50 to 75% of my time was doing transportation litigation and policy, right? Big highway fights, stuff like that. So not directly wildlife, sometimes wildlife were at play. But I learned a lot and was able to bring that to the wildlife work when SELC created the wildlife program. So I just want y'all to take away that, like, you can get here. Don't feel like every decision is zero sum. If you choose the wrong fork, then you're gonna not end up in wildlife law. You'll find your way.
Yeah, and I guess I'd add that please stay committed. The world really needs you guys. And the encouragement I give folks that tell me they want to do this path is to do as many internships as possible when they're in law school at places like SELC, CLF, Earth Justice, NRDC, like the typical like wildlife organizations, and apply for fellowships after you graduate from law school at those places, because there are often opportunities right afterwards. And when you're drafting your CV and your cover letter, don't be afraid to show your passion and commitment to wildlife conservation. I think sometimes we're also concerned about saying everything so professionally that sometimes the passion doesn't come through. And especially if you've taken a little bit of an odd path to get there, and especially if you've worked at a firm for a couple of years, like I did, pay for, your school loans. Don't be afraid to say the places you volunteer, even if you think that it doesn't matter that you volunteered at a local watershed or for a marine mammal stranding team or a beach cleanup team. Don't be afraid to put all of that into your cover letter, because often just looking at a CV, especially if you're at a firm and hoping to make a change, someone like me reviewing job applications wouldn't necessarily know that. So anyway, that's what I can add.
Thank you, Erica. I think that's really helpful. One other specific question, I think pertaining to both wolves and whales that we got was whether or not are there, for either of those species, are there financial incentives to protect? Like, how do you get sort of these competing, whether it's economic or landowner interests? How do you convince people to get on board with sort of a protection mindset, or at least get them to neutral?
At least for right whales, really the only way we've gotten there is fear of new regulations. It hasn't been, I mean, with the ropeless fishing trial, that gear is provided free of cost, like at least during this trial phase, but it may not be down the road, depending upon what the future holds. But it's really fear of additional regulation by the industry that has encouraged them to try new things.
Erica, have you found that that people are open to trying the ropeless, at least right now as it's free? Are people open to another way of doing things?
I think in Massachusetts, where the state and the federal government have had closures for a long time, fishermen are much more open to it because it's increased fishing opportunities. They haven't been able to fish in Cape Cod Bay for the last 8 to 10 years. So if they fish with ropeless and they can fish in there and are one of few people fishing in there, because they're an early adopter, then yes, they're pretty open to it. The cultural and political dynamics in Maine are very different. And although there are some really forward-thinking, courageous fishermen in Maine, they tend to want to stay under the radar with their participation, there are a few willing to speak publicly. But what we have seen happen is that one guy on a dock will start with new fishing technologies, and fishermen are curious, and they're also like, what is that? And also they are very much, at least my experience with them is that they really want to improve the product, and they want to make things work. They want to fix things and make things work. So when there have been issues with whether you could fish with this gear in challenging conditions or after a storm or whatever. They have been the ones that have made the gear modifications that have improved the product. So I think one dock at a time, one town at a time, it's the hope is that the species will last as long as it takes the industry to come around to, fishing this kind of gear where it's necessary. None of our groups are pushing for it everywhere all the time, just when and where it's necessary. So.
Thank you, Erica. Ramona, do you have anything you'd like to add?
I'll just say there's a lot of different ways that this can unfold under the Endangered Species Act. I thought of the Safe Harbor program and candidate conservation agreements and things like that, where it may not be sometimes it is kind of a financial incentive, but sometimes it's a back to that fear of additional regulation incentive that Erica was pointing out. And so those are some of the mechanisms that are there, not without their failings, right? They can work well in some instances, maybe less well in others. And then I'd add, I know out west with predators, there are different kinds of compensation programs. There are similar efforts, I think, to what Erica was describing, where certain deterrent materials or equipment are offered free of charge to ranchers or grazers concerned about large carnivores. So there are ways to do that. And I just want to thank whoever submitted this question, because these are the questions that I think we need to be asking to also learn how to better work with these communities. I know I made kind of a little bit of a comment of there being like small contingencies of vocal opposition. I don't mean to minimize that at all. It's really important that we figure out how to both save the species and work with these communities to find that appropriate balance.
I want to ask you sort of one final question. At the end of the semester, when I'm talking to my students, I usually like to leave them with one case, one win that really just has stuck with me all these years. I feel like any attorney who's practiced in an area that they feel passionate about has that case. And I hope for all of my students that they will have that case that really, or that win, or that, that really sort of drives them and makes them feel like, hey, I really did something good here. And I'm wondering, if either of you could share one of those wins or something that you really felt, proud of that you worked on in this space.
Want to go first, Ramona?
Sure, I can. I will say, I think one that will stick with me was winning a preliminary injunction in early 2021. So it was the height of COVID. When we filed this 2020 case over red wolves, it was in November, right? We were trying to figure out how to effectuate service as everywhere was closed. Like there's all sorts of fun stories from that. But we won this preliminary injunction that required the Fish and Wildlife Service, in essence, to start resuming its practice of releasing red wolves into the wild. After the agency had suspended those efforts for several years and the population in the wild had plummeted. So that was a really big win for us and very exciting to see those conservation efforts resume. And then that all led to that settlement in 2023 that I mentioned before. So that one will stick with me for a variety of reasons.
Thank you.
Yeah, and even though this case did sort of effectively get overturned by Congress, I think it's probably our 2024 win in front of Judge Boasberg at the cases Center for Biological Diversity v. Ross. But the upshot of it was that for the first time, a judge really weighed in on the intersection between the Marine Mammal Protection Act and the Endangered Species Act and said that you absolutely have to make a negligible impact finding under the Marine Mammal Protection Act in order to authorize take under the Endangered Species Act. And even though that sounds like a lot of legal mumbo jumbo, what that translated to was that you had to do a lot more mitigation and reduce risk a lot more in order to comply with the Endangered Species Act. And it, you know, it was probably the fear of all that more that you had to do that precipitated Congress taking action, but hopefully it'll have, like, you know, trickle down effects for other species now that we have, you know, a decision out there that says you really have to make this binding under the MMPA first before you authorize take lawfully under the ESA.
Thank you very much, Erica. You know, we have several folks who have asked how to help if your organizations work with I don't know if they're firms or others working pro bono. You know, Erica, Ramona, let me know, or if you want to add information in the chat, please feel free to do so. But I want to thank both of you for your time. I know this is a very, very busy time in this space. And so we just thank you for joining us today, for your really insightful and thoughtful comments. I'm glad you're hopeful. That makes me hopeful. So thank you both for your time today. We appreciate it.
Thanks for having us.
Yeah, thank you for having us. And maybe for those students who are looking to do something else, do you want to give them our email addresses, or?
Yeah, I'm happy to do
You
that.
can give them mine anyway. I'm not speaking
Yeah.
for Ramona here.
No, I was about to drop it in the chat, but that would be more efficient probably for Mary to send it out. Yeah.
Perfect. Will do. All right. Thank you to our audience, and thank you again to both of you.
Thank you.